Good afternoon, ladies and gentlemen. Welcome to BW Legal World's Saturday Solution segment, where we speak with experts on hot legal topics and latest legal developments. And today, we will be talking about or taking the pulse of the Insolvency and Bankruptcy Code, and which is going to be an analytical overview. The IBC code and regulations under the code have been amended on various occasions in short lifespan. Some of these amendments have been backed by judicial interpretations and recommendations, while others have been in line with suggestions provided by the Insolvency Law Committee. The code has also witnessed sector-specific amendments to resolve practical impediments faced by certain sectors, such as home buyers, guarantors, and others. To know more and to make this discussion fruitful, we are joined by Mr. Divyam Agarwal, Partner, JSA, Ms. Pallavi Pratap, Managing Partner, Pratap & Co., Mr. Vikas Jhawar, Partner, Saraf & Partners, and Mr. Arka Majumdar, Partner, Argus Partners. I am Asha Mauri, Managing Partner of BW Legal World, who has the honor of moderating this August session. Experts, once again, a very warm welcome to all of you and to our audiences joining us across various platforms. Let's dive right into the conversation with the panelists. We'd like to know from you, what are your thoughts on the new IBC regime of India? And I'll begin the discussion with Arka. Arka, the floor is all yours.
Thank you, Ashima. Thank you for having me here, and it's a privilege to be part of the August panel. We would come to more discussion. We will discuss in further details as to what we think about the recent amendments and this thing. But overall, if I have to summarize IBC in one line, it's a very dynamic legislation. It's a dynamic legislation because it's an ever-evolving legislation which takes into account, it is not a static one. It takes into account the problems that are faced by the practitioners, by the various stakeholders from time to time, and it continuously evolves itself. For instance, one of the topics that I intend to discuss is about pre-pack. When the IBC was initially introduced, there was no concept of pre-pack. But once they realized that what the actual situation prevails with respect to MSME, which is one of the very critical stakeholders in the Indian economy, the legislators realized the impact on the requirement of having a separate sort of an arrangement. We'll come to that in a bit, but I will leave the floor open to the other partners as well.
Thank you, Arka. Bikash, coming to you, please, your thoughts on the regime.
Hi, everybody. My view on the IBC regime is that it's been now 5 years that it's been on, and the experience has been mixed, right? I mean, there have obviously been some very, very huge successes. Okay, right. We've all heard of the resolutions which have happened, the companies which have been rehabilitated, takeovers which have been facilitated, right? The judicial involvement in the process has, in these successful processes, has been encouraging, right? The highest judiciary has, focused on the commercial intent of the legislation. For instance, one of the most important judgments, in my view, which has emanated, or one of the most important, principles which the highest judiciary has given is the clean slate principle, right? And that also said very beautifully in by speaking around Hydra head. So there has been some very, very great resolutions. But at the same time, there has been delays. Okay, the process has not lived up to its 180-day, 270-day, 330-day timelines. Right, there has been a huge delay, and those are things which have to be considered. So during this discussion, I hope I can speak around the latest Supreme Court order around the EBIX judgment, right, and how that impacts real world deal making. Right. So yeah, the experience has been mixed. There has been huge successes. The legislation still carries a lot of promise. Okay. But at the same time, I think process glitches need to be kind of sorted out here.
Absolutely. Thank you, Prakash. Divya, I'm coming to you for your remarks, please.
Hi. Good afternoon, everyone. And thank you once again for having me. So I echo the sentiments of my co-panelist here. It has been a topsy-turvy ride, and there have been some success, some failures. And to set the theme for my discussion, let me just give you some statistics. And I've been told by Ashima earlier also that you just keep throwing numbers, but that's how it is. How all this started, let's take a step back. And for our general audience who are not aware of what Insolvency and Bankruptcy Code is and why it was brought into force. So 2008 financial meltdown, everyone is aware of, and that time the lending rates were progressively lowered by the banks. They were, and it ultimately resulted in aggressive lending practice. This generous lending resulted in a gross NPA of 9.6% by 2017. And therefore, there was an urgent need to address all these NPAs. They were mounting day after another. And in this backdrop, the Insolvency and Bankruptcy Code was enacted by the government. The code ushered a concept of creditor in control with theme of maintaining corporate debtor as a going concern. The code has performed impressively in comparison to previous debt resolution mechanisms like SARFACI, DRT, and so on. For instance, the code led to a recovery of 1.73 lakh crores for 2019-2020. It's very, I find it very odd when we talk about lakh and crore in the same discussion. But that's the impact it has, that 1.73 lakh crore recovery has happened, and there has been corporate debtors, almost around 310 odd corporate debtors, which owed more than 4.99 lakh crores, and they have undergone resolution process as on January 2021. And you can imagine the efficiency of the code, that the liquidation value or the realization value of the assets of the corporate debtor were around 1 lakh crore, but the creditors were able to recover about 1.99 lakh crore, which is like 193% of the realizable value of these corporate debtors, merely because of the intervention of the Insolvency and Bankruptcy Code. However, as Bikash rightly pointed out, and all that glitter is not gold, a lot more ground needs to be covered. There are issues. If you would recall, in one of the strategy solutions, we had the former acting president, Mr. Bhaskar Mohan, and I was part of that panel. And during that discussion, one of the issues was that the NCLTs and NCLAD, they were vacancies, and it was working at half its strength. And thankfully, because of the Supreme Court intervention, we finally managed to cover some bit of those vacancies. So there are lingering issues. As in fact, ARC also pointed about, government is trying with PPAC for MSMEs. So that's a welcome move, in my view. So there are issues which need to be resolved. And my theme today would be on the home buyers as financial creditors. That's one area which I believe has resulted in literally 1.5 years of backlog, or if not more, for NCLT. And that's area I would like to address. Look forward to this discussion.
Thank you, Divyam, and we do love the numbers, so please keep them coming. Over to you, Pallavi. The floor is open for your comments, please, on the new IBC regime and your thoughts.
Thank you so much, Ashima. I'm sorry I couldn't join a little bit earlier. So my basic thought process for today, of course, we've had the legends already speaking about the IBC, so I would probably not have too much to contribute. But having said that, I think one of the things that I've been very closely watching, and I think the law is yet a little unsettled, is with respect to the personal guarantors and Section 95 and Part 3 of the Insolvency Code coming into picture, specifically with the notification being upheld in the Lalit Kumar Jain judgment. I see that I think that the law which is going to evolve around that part, especially with the Part 3, I think that is something that we, as practitioners of IBC, there is quite a bit that is coming through to the courts, and we've been seeing a lot of petitions which are being filed, which are traveling up to the Supreme Court, even if it is against interim orders. The thing is that it sort of gives a financial creditor the opportunity to actually collect his loan twice. I mean, of course, the monies are coming through the CIRP in terms of the resolution plan of whatever amount that is coming, and then they are also claiming it against the personal guarantor, which I think is an area which is still gray, and where I think the law still requires to be settled a bit. So that was the area that I wanted to cover today. But since I'm in Supreme Court just now on my legs, so I might not be able to continue so much, but I shall keep joining in between. And if you would allow me for that, I'm sorry about this a little difficult Saturday today.
Not an issue, Pallavi. We're glad you're able to join us. Just to let me know that if you have 10-15 minutes on you right now, could we start with you on that?
So, no, actually, my matter is about to reach on the court number 10. So
Sure. We'll have
will
you
just log
back
out now.
as soon as you're
All
able
the
to
best
join.
and thank you so much. Yes, I will.
Thank you, Pallavi. Thank you so much. Looking forward to having you return to us. And then we move to Arka again. Arka, you mentioned, the pre-packs, and if we could have some more details on that. What is pre-packs? What does pre-pack mean for distressed businesses? And how in live or with live examples, if you could let us know, has this changed the scenario for these companies?
Sure. Thanks, Ashima. So pre-pack is a very specialized system. So before that, let's me first go into that. What is the general CIRP process is? So when the CIRP process initially was there, it is still now, it is applicable to all the corporate debtors, right? Irrespective of whether it is an MSME state, it has an MSME status or large entities. So it had a one jacket fit all mechanism. And while implementing that, what it was realized is that MSMEs require a different sort of a framework, because MSMEs are obviously, they are less cumbersome. The structure is less cumbersome because it would not be taking loans from a multiple lenders. Similarly, there would be for an MSME to in a CIRP process, we have a 180 days period which can be extended up to 330 days, and as our experience shows that even within 330 days that process does not get completed. It becomes very difficult for an MSME to survive till that period. Okay, so we need to understand that MSMEs create a different class of creditors as opposed to a large corporate debtor. Once it was realized, and also what happened is that during the COVID, the stakeholders realized that it actually is important that for MSMEs to survive, and especially in the context of the distress situation that they are in, that you need to have a specialized framework. So to address that, the government come up with so there were obviously discussion on the pre-pack regime, and the government came up with the pre-pack solution. How is a pre-pack different from a CIRP? CIRP is a creditor-driven process. What happens is that the moment it's the CIRP is admitted, the board of directors gets suspended, a resolution professional comes into the picture, the resolution professional undertakes the operation, it oversees the operation and everything with the help of the creditor committee of creditors. MSM, the pre-pack is a different. Why? Because it is a combination of a debtor in possession with creditor in control. What do I mean by that? It means that when the pre-pack is initiated, and it is not that the board of the company gets suspended. The board of the company continues to exist as it is. However, it needs to take instruction from it gets tempered by the committee of creditors. If I have to go very briefly about the process that is involved, what happens is that it allows the MSME to identify the stress. Once it identifies the stress, it takes the approval of the board, it takes the approval of its shareholders, and it also takes approval of the unrelated financial creditors, saying that, look, we want to initiate the pre-pack mechanism. At the time, what it happens is that it provides a base resolution plan, or BRP. So if you follow the various committee minutes and this thing, the entire reason of this base resolution plan coming from the company itself, because the committee stated that, look, we would want the company to survive. We would want the management to have an active skin in the game. So for that active skin in the game to happen, It has to be that. So for that, you need to be incentivized, right? Because if I say that, look, that other parties, the third party resolution applicants can come and bid for your company and take the company out of you, it would not be incentivizing the management to ensure that the stress that they are going through, to tackle it, to preserve the existence of the company, and to address the reason for the default. For that's why it's something which starts from the corporate data itself. Okay, the management provides for the base case resolution plan, and if that base case resolution plan is approved, it's approved by the unrelated financial creditors, then along with all the information, you go and make an application to the adjudicating authority. Adjudicating authority obviously constitutes a COC, and then the CT submits the base case resolution plan. If the base case resolution plan is accepted by the COC, then it continues as it is. If it is not accepted by the COC, then the COC invites for the third party resolution applicants for submission of resolution plan. So here also, if I have to compare, if I have to compare it with the CIP regulation, let's understand the differences. First difference is that who are the eligible entities who can initiate who can take the benefit of the MS pre-pack. It is an MSME who can only take the benefit of the pre-pack. Okay, as opposed to all other corporate debtors who can take benefit under the CIRP regime. But it is not
So could
that
we have an example of some of these companies?
So right now, we only know that it's the GCCL infrastructure. It's an Ahmedabad-based company whose pre-pack has been approved. But if you look at who the MSMEs are, and if you look at the 1st July 2020, there has been an amendment which specified that what are the MSME criteria are. So depending on the infrastructure, it is 1 crore, 10 crores, and 50 1 crore, 50 crores. Just 1 second. It's 1 crores, 10 crores, and 50 crores is when it is an investment cap, and in the terms of the turnover, it is 5 crores, 50 crores, and 250 crores. If you fall within the bracket, you fall within the MSME tag. Okay, but again, even though it is remember, it is an option. An MSME can always go for a normal CIRP process as well. Okay, if I look at the default threshold, if under section 4 right now, for a CIRP to commence, the minimum default has to be 1 crore. Okay, for pre-pack, the minimum default is 10 lakh rupees, because obviously it's an MSME. Okay, what about the timelines? The timelines for CIRP is 180 days is the normal CIRP process, which can be extended up to 330 days. Whereas in case of a pre-pack, it is 120 days. You have to submit the base case resolution plan by 90 days. The adjudicating authority has to approve it within 120 days. So it's a more time-bound process. What happens in the event that this particular pre-pack mechanism does not go through? None of the either there is no, all the resolution plans that have been submitted are not accepted by the COC. What happens? Nothing happens. The matter again goes back to the normal situation as was there before the pre-pack was initiated. And then if the company wants, if the other company, corporate debtors or the creditors think that if the company needs to go into CIRP, this thing, they can. So there are 3 options which are available. It can go to pre-CIRP situation, it can go into, it can be converted into a CIRP situation, or it remains as it is. Okay. So if I look at that, this is the benefit of the time period and the difference between the pre-pack mechanism and a normal CIRP is. It's something which is very specific to MSME categories. And let's see how it evolves over the time, what jurisprudence has to say about that. Vikash, if you have anything further to add, please.
Yes, I was going to come to Vikash for this. Vikash, your pointers, please, on what Arka has just mentioned.
I think Arka has kind of explained it very, very succinctly, how the process would work and what are the benefits of the process, right? And, I just think that, the government really needs to, examine and push pre-pack even for larger entities, beyond MSME. right? Because if you see, pre-packs already have a safeguard built in that pre-packs can be approved. The management pre-pack or the promoter pre-pack can be approved only if without any competitive process, only if the operational creditors are not suffering a haircut, right? So, and if the operational creditors are suffering a haircut, then some kind of a Swiss challenge type of a process needs to happen, right? So, so since there is an inbuilt safeguard, I think, the challenge of timelines and the challenge of, enough investor interest, challenge of uncertainty also lies in the regular large cap, large companies. Okay. And so pre-pack should be enabled there. Already these companies are doing restructuring outside of IBC, right? The value for everybody would significantly increase if they can take the benefit of IBC also, right? So, the clean slate benefit and, some kind of a more. So I think the government should really give it a thought. I am told that the government is going to come. I mean, not told in the sense. I think we all read the news items that there may be amendments around the budget session. I hope they consider bringing large companies also, large credits also within the scope of pre-pack. For that, they will need to address 29A issues, of course. Okay, so there is a philosophical issue around that which will need to be addressed. But yeah, so that is what I kind of have a view around pre-pack.
Thank you, Prakash, and thank you, Arka. Looks like a welcome move. So you're wanting more people under the bracket and the umbrella. Looking forward to Divyam's, take on home buyers. Divyam, you were mentioning treatment of home buyers as financial creditors under IBC is something you're going to speak about. So we'd love to know more on that.
Sure, thanks. And I wholeheartedly agree with Bikash and Arka on the pre-pack issue. This is a very interesting topic as it captures a large audience, home buyers, and the definition itself is brought from the real estate sector, which is an allottee who's also loosely called as a home buyer, and general public, if you see, is impacted by this amendment. This entire issue started in 2018 when an amendment was introduced in the IBC, which treated or considered home buyer as a same as a financial creditor. For the audience, financial creditors have superior rights under IBC, such as the rights to have representation in the committee of creditors. That's one of the important rights they have, unlike an operational creditor. So they have a higher pedestal in the food chain, and therefore this was an important right created for the home buyers as a class. But this opened floodgates. Again, taking an example of numbers, almost 2,000 odd cases were filed within a span of 1 year when this amendment was introduced in 2018, and within 1 year 2,000 cases, and next year another 1,500 cases were added to it. The home buyer issue was put to challenge before the Honorable Supreme Court of India in the case of Pioneer Urban Land and Infrastructure. I was part of that decision, and that time one of the issues which was raised before the Supreme Court was that why would you treat them as a same category as any financial creditor? But the Supreme Court upheld the amendment of 2018, and they said that a sale agreement between the developer and home buyer has the commercial effect of a borrowing, which means that money is being paid in advance for a temporary use so that a flat apartment is given back to the home buyer. So essentially, this amendment was allowed. The Supreme Court granted its impetus to it. This continued the problem of too many cases to NCLT. One of the surveys conducted by the Economic Survey of India, they said that 67% of cases which were filed in NCLT at that point of time were home buyer and allottee cases. I've seen these, and I'm sure Bikash and Arka would have also seen those cases where 100, 200 cases were listed before one bench, and they were having no idea how to deal with it, because those are massive numbers. And not only the lawyers used to be there, but imagine the home buyers who we all share the plight, but they approached NCLT and they were creating a huge ruckus out there. Um, the government realized that this cannot be the way to function. This is not what NCLT was meant to be. NCLT was more to do with any kind of a financial solutions around the corporate debtor. Accordingly, in and around January 2020, they introduced an ordinance by which they amended or in fact inserted 2 or 3 provisos to Section 7(1) of the IBC. Section 7 pertains to financial creditors, and later on, ordinance was converted into an amendment in March 2020. The amendment was essentially, the proviso stated that in case of home buyer or allottees, they created a threshold, that is, you need to gather 100 home buyers or 10% of the total number of home buyers in a particular project, whichever is a less of the two, in order to approach NCLT as a group. So the right from one individual home buyer triggering the corporate insolvency resolution process was in a way taken away, and it was clubbed into a more of a group or a class where you have to gather either 100 or 10%, whichever is less, and you can then approach. In that, again, this issue was taken up till Supreme Court, because this time the constitutional validity again was challenged before Supreme Court. The home buyers were not satisfied with this amendment, because their argument was that you have taken a valuable right away. You have created a class within a class, financial creditors, and there is a sort of a clear discrimination between other financial creditors who can, so long as they are meeting the threshold requirement, 2 lakhs, now 1 crore, if they can meet that, then they can approach. Then why cannot a home buyer be allowed the same treatment? This issue was brought to Supreme Court, led by a judgment of Manish Kumar versus Union of India. Unfortunately, I was again part of this decision as well. Again, this issue was dealt before bench of Supreme Court, highly litigated for months, and Supreme Court was able to deliver a decision again upholding the constitutional validity of the amendment, and this time declaring that yes, this class within a class is correct, because under the current scheme of things and how the insolvency process is functioning, it's important that there should be a commonality of thought process between various home buyers or allottees, and only when they as a collective group believes that the company cannot function in its current management, then they can approach insolvency resolution process under IBC. And they otherwise have various other remedies in RERA, consumer matters, and other or arbitration or whatever is prescribed in their buyer's agreement. There are remedies available, so it's not that they can't recover their money. But if their thought process is to that they have lost faith in the management, then they can approach as a collective group. Interestingly, there were important findings in the Supreme Court's decision, where this first of all classified who is an allottee, and this would be relevant for the audience also to understand who would classify as a home buyer. There is a requirement that merely because there is some kind of a allotment where there is just a promise through a brochure is not good enough. There has to be a proper allotment. Again, constructed number of units are not relevant. So and this is important. I'll explain you why by way of an example, that if there is a project where there are 100 constructed units and there are allotments are only 50, then in order to satisfy the requirements of the provisos to Section 7, all you need to do is to satisfy the number with respect to 50 and not the total 100 constructed units. So in this example, all you need would be 5 home buyers who believe that they have a collective interest of not going through with this current management. They can approach. Then
this is the 10% thing that you were mentioning.
That's right. 100 will not apply because the number is 50. Whichever is less is what is applicable. Then another issue again dealt by Supreme Court was that when is this number going to be seen? What is the area where you will draw the line? And the Supreme Court said that it is on the date of presentation of the case. So you would see this threshold being met on the date of presentation. Though I would personally believe that this issue still has a niggle. It needs to be resolved, because what happens to those cases where where on the date of the presentation the number is met, but some of the individual or the allottees or home buyers want to settle the matter out with the builder, or they believe that they may not have the same issue, uh, and that issue still requires some consideration from Supreme Court, or in fact, for that matter, NCLT and NCLAT. Apart from that, the other issue which they dealt was that what is you have to seed collectively as 1 crore. As you know, that 1 crore is a default requirement now in NCLT, and will you see that 1 crore per home buyer? Will you then do a 10% or something, or how will you arrive? And the Supreme Court said that no, we will just see it of one allottee, and that's good enough. If one allottee has breached that threshold of 1 crore, that's good enough. Or you can approach as a collective group. It's just the number that needs to be breached. But again, that lingers a point, that what happens to allottees per se, who have no default, and yet they have been added as a group just to make that number. So we need to see both sides of the coin, whether is it still being misused? Is there still a mischief there? I believe so, because sometimes allottees approach as a group where number of allottees have signed conveyance deed, number of them have transferred their flats, and yet they are, just to fill in the number, they are there. So Supreme Court and the legislative intent was that let them come as a collective group. That has been addressed, which is a very welcome move. That has considerably reduced the burden on NCLT. But there are, as I said, some lingering issues which needs to be resolved, and hopefully over a period of time and by judicial intervention, we will have those issues also put to closure, and finally achieve something which is important for the larger interest of the corporate debtor.
Absolutely. Thank you so much, Divyam, for letting us know about the whole thing. I would also like to ask our audience if they have any questions related to what each panelist is speaking about. Please do write to me in the chats, or we'd be happy to take those questions at the end of the session. Coming to Bikash, you were going to throw some light on deal making and IBC. Would you please elaborate on how that is impacting the deal making?
Okay, yeah, hi. As Arta had, I think, briefly referred to in his, discussion around pre-pack, the process around the regular CIRP, right? So the regular CIRP really entails the creditors, through the resolution professional, taking control over the company, running a process which is an open bid process. Okay, right? Receiving different interest from different bidders, and based on that interest, the committee of creditor kind of chooses a plan and then presents it to the NCLT. NCLT approves it, and then the plan gets implemented, and the bidder takes over. Right now, in a sense, what this is an M&A transaction, right? Where a company's control is being moved from existing management, promoter, shareholders, and it is being given over to the new person, right? And when a new person is taking it over, like any other transaction, like the way we would go ahead and buy things, right? Forget an M&A transaction. When we go and buy flats, cars, etc. We all value something at a certain point in time, right? So people have provided value for a particular corporate debtor. Bidders have provided value for a particular corporate debtor at a particular point in time, assuming a certain state of affairs, right? Now, we have seen this regularly, and this really does emanate from the fact that judiciary has been overburdened. The NCLT and CLAT systems have been overburdened, though there have been effort to kind of ease that out. There are additional benches of NCLAT which have been set up. Chennai has an NCLAT bench, etc. Right? So there have been effort, but the judiciary is overburdened. Divyam mentioned, right? I mean, there were 2,000 cases filed by home buyers, right? And that's just 1 year, right? And the next year, his statistics suggest another 1,500 got filed, right? And these are like, main applications. There are, in every case, there are hundreds of interventions, injunctive actions sought. So the process is very, very messy, and the judicial process becomes very, very messy and deeply burdens the system up, right? It clogs up the entire system now, which means that the approval process, okay, of the plan, right? So the COC approves it on day zero. By the time NCLT gets to approving this particular plan, right? At least in my experience, it's nowhere less than 6 to 8 months. Okay, right? So, and after that, then is the plan implementation process, which on an average takes about 30 to 45 days. Okay, sometimes 90, 100 days. Again, it depends on whether there are any other approvals, conditions, etc. to be met. So the process is a fairly time involved process, right? I mean, we're talking about 9 months, 10 months, right? Who takes the risk of the asset during this period, right? As I said, the bid has been made on a certain date before COC approved the plan on the state of affairs as it existed at that particular point in time, based on due diligence done at that time. We, as M&A lawyers, people who do M&A here as lawyers, investors, students who review M&A, right? They would understand that, people have a material adverse effect carve out or a change in fundamental assumptions, right? So in a IBC situation, the bidders have the same question, right? What happens, right? If the bid process is if the bid approval process is taking too long, who is taking the risk for that entire period? Right? If a lightning strikes the companies, factories, and the factory is, burnt out, okay, right? And for a moment, let us say there were no insurances, okay, or even if insurance was there, right? There's the time cost of rehabilitating you. Just because insurance comes, you don't, do a magic wand and hey presto, the factory's back again, right? So who takes the risk? Now, bidders have sought to pass that risk on to the COCs. A lot of COCs had, reluctantly agreed to it. Okay, right? That sure, material adverse effect, if it happens, you walk away or the bid price changes and stuff like that, right? Now, this situation came about in a couple of cases where it went all the way to Supreme Court, and Supreme Court has now held that you can't really have a walk away from a resolution plan, right? Once you've given a resolution plan, you are kind of bound by the resolution plan, and MAE carve-outs are not available. While recognizing, Supreme Court has recognized that time delays are also a challenge, and they have kind of like, pointed out that NCLTs and NCLATs need to look at things, much more earnestly and urgently, right? Especially the approval processes. But they have said you can't walk away from a plan on even a material adverse effect, right? Now, this, according to me, could have a detrimental effect on resolutions, okay, right? Because unless the timeline for the processes, for the approval processes are dramatically shortened, okay, because a 10-12 month is genuinely a fairly long time to run a risk on a deal, right? And this is, I'm not even talking about the fact that commercially the deal may not be worth it 10 months later, right? You've made a bid when the economy is booming, and let's say or that sector is booming. 10 months later, 12 months later, by the time NCLT approves, NCLAT challenges get cleared, and then Supreme Court challenges get cleared, it may be 15 months, right? Okay, so the sector may have changed dramatically. Okay, so who takes these business risks? Okay, because the bidder never intended to take these business risks, right? So these are questions which will need to be addressed by the government, okay, at some point in time, right? Hopefully they will address it earlier than later, okay, because otherwise bidders will start finding a challenge to handle bids within the IBC. They would rather than do deals outside the IBC, okay, which will have again a very negative effect on value maximization, on fair and equitable treatment of all concerned. Okay, so this, according to me, will be something which will need to be addressed. One way of addressing it is something which Divim pointed out, that staffing up the NCLTs, NCLATs, with many more judicial and technical members, so that each one is able to kind of focus and close matters, right? So that is one, but yeah, I think this is something, according to me, a major concern right now. Okay, when we act for resolution applicants, this is a question which, and in fact, not just for resolution applicants, when we act for COCs and RPs also, right? This is a question which everyone is grappling with, as to how do you handle this risk? Okay, right? So yeah, this is
Thank you,
something.
Bakash. Thank you for throwing light on that. Then there are also some of the questions that have arrived for you. If you'd like to take them, these are long questions. I'll take the first one. This is from Sarthak Bhatta Mishra. So I'll read it out as it is given. Sir, you mentioned of how the PPAC regime should also be encouraged for larger companies, corporations which are slipping into insolvency. However, this gives rise to two concerns. The first one being the company essentially is pushed into insolvency by its own management. It does not seem reasonable to allow the same management to alienate the assets of the company, as this could turn out to be prejudicial to certain stakeholders. Do you agree, Bikash? We'll take the second one later. Let's address this first.
So see again, as I mentioned, prepacks are not a very straightforward structures which has been given, that just because you are the management, your deal will have to be approved, right? Okay. And Arka can chip in on this, but prepacks are possible only if the relevant financial creditors agree to the deal, and provided that the operational creditors don't suffer a haircut. Okay, and if they are suffering a haircut, then there has to be an open auction process, right, where third parties, like the way currently the deals happen, will get a chance to kind of provide their interest and their plans in. So the prospect of someone suffering, okay, or being prejudicially affected, okay, because the management decided to act in a arbitrary manner, is low, in my view. Okay, given the process itself allows third parties to come in, right? And we have to also kind of recognize here that what are we really talking about, right? I mean, if a prepack doesn't go through, fine, you take it to the normal CIRP, right? It is not as if deals are getting, as if bidders are lining outside your door, okay, trying to take over company by jumping over each other's heads, right? It is not like that, okay? That has happened in a few deals, okay, where there is significant competitive interest, okay? Most deals are not like that, okay? So to rehabilitate the company, right, maybe promoters are best placed, okay? I understand that promoters may have had bad governance styles before, okay, but maybe it's time to give some of them a second chance. I'm just saying that see, the bad promoter problem is there in MSMEs also, right? It is not as if it is a very unique large company challenge, okay, right? The bad actor problem is there throughout the system, okay? If we are happy to work with them for MSMEs, we have to think of them for the larger ones, and the creditors, the financial creditors, as and I say this in a very narrow sense, okay, as fiduciaries holding responsibilities in COCs, will need to exercise good judgment when they are approving, rehabilitation schemes. And by the way, they can also do this outside. As I said, June 7th circular, people are restructuring. So there is, I don't think I am finding it significantly risky if large caps are also allowed to come under pre-packs. But Aka, your views here, if you could.
Sure. I think, thank you, because and I think there are other safeguards also which are there in pre-pack. For instance, while it is a debtor in position, that debtor in position can also be changed. The NCLT or the adjudicating authority has the power to replace the existing management with the RP, and they when they think that the company is being operated in a fraudulent manner. And remember that ultimate power continues to vest with COC even after the pre-pack has been initiated. With 66% vote, they can terminate the pre-pack. They can again go back to the normal situation. So I think that there are enough safeguards and to take care of that particular situation.
Thank you, Arka. There's also a follow-up on this. I would throw this out to all the panelists. It's a long one, so please bear with me while I read this. There would be severe concerns of transparency which would arise in PPACs for larger institutions who would be facing a threat of insolvency, since the existing management would be in charge of the company's operations, and thus there would always be apprehensions regarding the justness of the entire operation. Such a process may also induce a lack of confidence amongst creditors, especially the unsecured, and they would run to the NCLT and file cases against the corporate debtor. All of this would increase the time taken to bring the matter to a reasonable conclusion, thereby defeating the premise of PPACs in itself. In your experience and opinion, this is meant for Bikash, but we'd also open it to others. What kind of amendments do we require in the law as it stands to assuage these concerns? Bikash, starting with you. You're on mute, please.
Yes, I think part of this was already answered by Arka in the previous question around the fact that it is not as if debtor in control is an absolute phenomena. Okay, right? In that it's an absolute phenomena in pre-packs. There is possibility for the debtor to be dispossessed of his control, as also there is obviously the RP still there, right? Who is the overall still the supervisor around the process and the person who reviews and handles the process. So that is there. Now, as to creditors feeling concerned, see, you can't do a pre-pack without creditor consent in the first place, right? So it is the reason the process has reached pre-pack is because the creditors were comfortable taking it there. Okay, right? So in terms of amendments, see, my reading of pre-pack at this moment, it is being drafted very, very intelligently. Okay, immediately, off the hand, I can't think through any significant amendments. As I said, if pre-packs have to be extended to the larger companies, then 29A is what will need to be addressed. Okay, right? Because obviously pre-pack assumes existing management's ability to provide a rehabilitation plan, right? So yeah, but I think Arka studied it much more. So
thank you, Vikas. Thank you for your thoughts on this. Arka, coming to you, and there seems to be a pressing concern here about what happens if large caps are included. So, your thoughts on how we can elevate some of these concerns.
No, but I echo what Vikas had mentioned. I don't think that right now there is anything specific tweaking around which is required until and unless our experience with the pre-pack throws up something different. Because see, we discussed about that in the event that lack of transparency is there, I can always go back and that management can be changed. In the event we think that it is being run in a fraudulent manner, we still have the benefit of the PUP transaction. If it is a fraudulent transaction, we can again ask that person who benefited from that unjust enrichment to return back the benefit. So whatever is the provision which is there already under CIRP, it continues to be there even so far as pre-pack is also concerned.
Absolutely.
So not any tinkering that we can think of right now. But again, as I had mentioned in the beginning, that it's a very dynamic and evolving statute. And I'm sure that in the event, for instance, 29A came into picture only once we realized that it's actually giving the promoters the backdoor entry. And to prevent that loophole, the 29A was introduced. So if similar, we think that it is the system is being taken on right, I'm sure legislature would come up with a different solution.
And in your opinion, right now, there are no red flags that need any kind of special attention, as
It's
mentioned by.
not really, because it's again, on a very primitive stage. It's just have started. We have experience of only right now. I am aware of only one case where the PPAC has been admitted by NCLT. With more and more cases and more experiences, I'm sure that there would be the concerns that have been raised are valid concerns. I'm not saying that they are not, but we do not right now have any proof that how the system can be manipulated at the moment.
Absolutely. Thank you so much, Arka and Vikash, for clarifying that. We also have another question from Ishan Chopra. We throw it to the panelists, whoever would like to take this. What are your views on concessions and reliefs which have been granted by NCLTs lately in going concern liquidation sales?
So let me, at least put my thoughts here. So in terms of concessions and reliefs which have been granted in liquidation as a going concern, none of those reliefs and concessions are extraordinary. Okay, right? I mean, you are taking the company in liquidation. Okay, see, liquidation as a going concern is a fiction which is very unique in Indian law, right? Okay, it doesn't generally happen. What is liquidation? A liquidation is you take the company. Okay, I mean the liquidator takes over the company and he disposes the assets once independently, right? And those assets obviously go without liabilities. Okay, right? Because the liabilities remain with the company, and then whatever value you get from those asset sales, you run it over the waterfall of distribution, right? The distribution waterfall, and people get their claim settled, or if they don't get it settled, too bad, right? I mean that is the way liquidation happens. Now, liquidation as a going concern is a structural innovation created in India, but it doesn't take away from the basic philosophy of liquidation, which is that you have sold the company, and with the money which you are receiving, you have to discharge all the pre-liquidation claims, right? The person who will take it is going to take it without the history of the past affecting them. Okay, so I think the reliefs, concessions, whatever are being granted, are in line with what the intent of the code is, intent of the liquidation process is. But if Ishan has any specific relief which he wants to discuss, that I can. But I'm again giving a more generic and general answer.
Thank you, Vikash.
Even in fact, I
Yeah,
would just sorry. So I'll just also quickly add to what Vikash pointed out, and I completely agree. The sentiment and in fact the intent behind the code has been that you maximize the liquidation value. That's always been the case. But and it's not that concession is given without any application of mind. Release have been granted. The idea has always been to ensure that the company continues as a going concern, and it is only when we achieve a stage which is called as a corporate death, then the liquidation process kicks in, and where these reliefs are granted. And it's not the case that NCLTs have been allowed to go unabashed. They can do whatever they would like to do, and there have been judicial interventions at the level of NCLAT and Supreme Court, whether it is for what kind of a liquidation value you're going to arrive at. That has also been discussed at the Supreme Court level. Even prior to that, resolution plans, which is one of the topic we were earlier discussing, that can the resolution plans which have been approved, can they be modified by NCLT? Again, that has been subject to a lot of discussion before Supreme Court. Various judgments have been passed, so it's not a unhindered regime altogether. But yes, So long as the intent is to maximize the value of the corporate debtor at the time of liquidation, we should always encourage such kind of an interventions.
Thank you, Divyam. Thank you so much. And Arka, any additional pointers to that?
Yeah, not really. The only thing is that we have to appreciate that it is a very unique situation, because the company or a company which is being sold on a going concern basis during a liquidation, I think it's an anathema. A liquidation means it has to stop. The entity ceases to operate. There has to be a death, which was actually the one which was raised by principal bench in one of its cases, but which subsequently enclad in the Mohan James. They state that no, what liquidator that IBPI had done in introducing section regulation 32A is correct. But I still cannot get my head around that particular fact, that can you even have a company being sold on a going concern basis during liquidation? But if it is allowed, and assuming that that is allowed, the reliefs that are being claimed is something which is required for company to be run as a going concern. If I do not give this relief, the company will not be able to run on a going concern basis. So yeah, that's what where we stand.
Thank you so much, Arka. I hope that answers Ishan's question and also Sarthak's. Thank you so much, audience, for putting in those questions to our panelists. If there are no other questions, or if there are more questions, please do write to me at ashram@businessworld.in, and we can take those questions to our panelists again. I think we were waiting for Pallavi to join, but unfortunately, she's unable to join us from her matter, or maybe is still engaged in there. So thank you so much, panelists, for joining us today for this discussion. There's so much to soak in, and I feel even our audiences have been very interactive today. So thank you so much, panelists and audiences, for joining us. It's been so good to have you today. Thank you so much.
Thank you very much. Always a pleasure.